All right, I'm sure some of you caught the video I posted earlier in the week on Monday where I mentioned that I had the luck and the honor of being placed on a jury to hear out a court case and bring justice to the land. It's okay. Let out your Mayanite trial references in the comments. Feel free to do so. And I know that since that video went up, or since you heard about it through Twitter streams or whatever means, you've all been sat there waiting with bated breath and suspense for me to be able to share all the juicy details about the trial, right? But I couldn't say anything while it was ongoing because when you're on a jury in the United States, you are forbidden from saying any specific details about the case until the matter is closed. All you can say is you're on a jury, about how long the case might last. But as of a few days ago, we issued a verdict. The matter was laid to rest, and I can talk about whatever I want. So here I am about to make a video I never thought I'd be making, where I'm gonna talk about my first ever experience in a courtroom on the jury of a trial. You know, it was kind of interesting. I don't hope to do it again anytime soon because it does yank you away from your life. I will never again take for granted being able to sit in front of my computer all day because apparently that can go at a moment's notice. But I tried to make the most of things and it was interesting. And I guess I gained some life experience, so that's got to count for something, right? So without further ado, let's get into the trial. I'm hoping I can do this in a clear, concise fashion, and the video won't be an hour long, but I'm not a judge, I'm not a lawyer. This is my first experience in a courtroom, so I'm probably gonna like mix up the order of witnesses or use pronouns when I should use proper nouns and be confusing, but I'm gonna try. This is like the most amount of notes that I've ever written for just a straight to webcam vlog before, so hopefully I can keep things straight. All right, so drum roll please. The trial was an eviction case. So you had a landlord, a guy who owned the property, who was trying to remove one of his tenants, the defendant, from the property. The landlord alleged that the defendant had started a fight with the son of another tenant, and then that tenant, who's the mom, also ended up becoming involved in the fight. And the defendant, on the other hand, alleged that the son of the tenant started the fight and he was simply acting in self-defense, and therefore he should not need to be removed from the property. Now, I should mention, despite the fact this entire case sort of revolved around a fight and who started it, there were no criminal charges. It was a civil eviction case, and so the only thing that we as a jury were ruling on are whether or not the defendant was to be evicted. There were no criminal charges at all. And what I found interesting from the very beginning is there were no cameras in this entire building, and the only two people who were present inside of this mailroom entrance to the building at the time the fight started were the defendant and the son of the other tenant. So at the end of the day, from the very start, it was simply a case of one person's word versus the other. And so I found it interesting that at the very start, the plaintiff obviously already was convinced that the defendant had started the fight. Otherwise, this lawsuit would not have gotten this far, and the landlord would not have taken it to court in the interest of getting rid of the defendant. So I'm thinking to myself, even if there are no cameras, the plaintiff's got to be pretty sure of himself, so there's got to be some other smoking gun, right? And so I'm kind of waiting for that the whole time. So the plaintiffs are up to present their case first, which means they're the ones calling in witnesses of their choosing, the ones that they think are going to help their case. And whenever a witness takes a stand, both sides have an opportunity to interview. There's direct examination and cross-examination, and any witness testimony is considered evidence unless the judge strikes something from the record for whatever reason. So the plaintiffs have the landlord, who is the plaintiff. They have his property manager, who's involved in running the building on a more day-to-day basis. And they've got the son, who was directly involved in the fight with the defendant, and the mom, which is the other tenant, who also became involved in the fight, as well as a process server, but she was less relevant to what we actually ended up ruling on. So landlord takes the stand first. He's asked, well, how did you hear about the incident? How do you know what happened? He says he was more or less informed by his property manager, and that he had a little bit of direct contact once with the defendant, but otherwise it was fairly limited. Property manager takes the stand. He explains that he heard from tenants, including the mom, the son, the defendant, some others who heard the commotion after the fact. And then the more crucial witnesses for the plaintiff are the son. He takes the stand. And I should be clear here, when I say son, he's 24 years old. We don't have an adult man, the defendant, beating on like a child or something. It was a fight between two adults. And so he's being asked about what happened, and he claims that he and the defendant are both inside of this mailroom entrance to the building. It's like you have the mailboxes, and then you have some stairs that go up to the second floor, which house all the units except for the defendants. The defendants unit is right on the sidewalk in the front of the building, facing the street. And so they are both getting mail, and the son, he alleges that the defendant kind of purposefully shoves into him as he's walking by, and then as the defendant is holding the door open, seeming to exit, the defendant starts taking swings at him, the son. And then after that, though, it's all a bit of a blur. All the questions about specifics of the fight, the son says, well, my mom overheard the commotion. She ran down the stairs and she became involved, but somehow we ended up going from the mailroom out down the driveway towards the front of the property, the sidewalk where the defendant's unit is located, on the grassy divider between the sidewalk and the street. And it was kind of a blur of teleportation between the mailroom and getting out to the grassy area almost at the street. And so he took, on some occasions, up to like 10, 20 seconds to answer a yes or no question that, I mean, you would think would be pretty clear to recall. I mean, I suppose if you get into a fight, it could be a bit of a blur, especially if you were hit in the head and you got a concussion, but it didn't seem like anyone actually got knocked out over the course of the whole fight. So it was very blurry testimony. Didn't seem all that reliable. So then they call the mother to the stand, and the mother says that she heard commotion downstairs, and when she heard the yelling, she runs down, and then she got hit or something, and then her body went limp, and it's all a blur, and she doesn't remember anything other than somehow being in the mailroom, and then she ended up out in the sidewalk, grassy median area near the street, and she doesn't remember anything else. She said her body went limp, and that was that. So it was very hazy, fuzzy testimony. And I mean, the mother, I mean, if she had gotten hit and she was unconscious, I could understand it all being a blur, but, and we'll get into it later, it didn't seem like she actually got knocked out or anything like that. So that was the plaintiff's case. Then we move on to the defense, and the defense has on their end to call, they have the defendant's wife who witnessed the fight. They have the defendant himself. They also have a third-party neutral observer. And that was, on its own, a bit of a telling thing, is that the only neutral observer who witnessed this fight is being called by the defense. You would think that if the plaintiff had a strong case, a smoking gun, that the plaintiff would be the one who had a neutral third-party observer who witnessed the defendant starting the fight. So anyway, but more on that later. The defense starts off by calling the defendant's wife to the stand, and she has a pretty clear recollection of things. Granted, she wasn't directly involved in the fight, but she says she asked her husband, the defendant, to go get the mail. Then a few moments later, she hears some commotion. She runs outside, and what she sees is the defendant from the front being attacked by the son. He's throwing punches. The wife, claims that the defendant's not throwing punches. The defendant later says, well, I mean, I was throwing punches to defend myself, so we can contradict that. But the wife also says that the son's mother, the other tenant, is hitting the defendant from behind. So the defendant is basically just being double-teamed, sandwiched by two people punching him, is what she claims. She claims she runs back inside the unit upon seeing this, grabs her phone, calls the police, and is on the phone with the police as things sort of start to fizzle out. She sees a moment of opportunity to go in and kind of grab her husband and try to pull him away and get back in the unit. And the police end up arriving after. They took statements from various people, but no criminal charges were pressed. And there was another telling thing about her testimony, which is that she called the police, which you would think that if someone saw their husband being the aggressor in a situation, they probably wouldn't be terribly inclined to go and call the police immediately for fear of getting their husband in trouble. So the fact that she immediately ran to call the police, psychologically, you would think that she saw her husband as the one who was in danger of being assaulted in that situation. So that was an interesting part about it. So next up, they call the defendant to the stand, and he has a very, very clear recollection of things, and it matches his wife's account of things. And also, as for the instance of just when the defendant and the son of the other tenant are in the mailroom, he says he's over at the end of the room. He's getting mail at his mailbox. As he's going to walk out, the son, who's also getting mail at his box, purposefully kind of shoves back into him as the defendant's walking behind. And from there starts throwing punches. He's trying to kind of get back out the door towards his unit. He is throwing punches back in response, but he's defending himself because it was initiated by the son. When the commotion started, the mom runs down the stairs and she starts punching him from behind. This is what he claims. And then they end up out at the sidewalk and over at the grassy area. He claims never once did he lay a hand on the mother. He was only throwing punches back in response to the son who was in front of him. And that was his story, and it matched up fairly well with his wife, which, okay, you could take it with a grain of salt that their stories match up with each other, but they do share a lot more detail than the simply I blanked out that the son and the mother shared on their end, which the way I took it was, I wonder if they've been advised, don't go into too much detail for fear of saying something that's not truthful. It sounded like there could have been some things being covered up. And so after hearing the very clear stories on one side on the defense versus the plaintiff, started becoming a little bit skeptical. Then the defense calls up the neutral third-party witness, and he more or less confirms everything that took place after they exited the mailroom, because he heard the commotion as well. He runs from his building, which is adjacent to the landlord's property. He runs out and he sees the defendant being hit from the front by the son, defendant's returning punches, but also the mother is behind the defendant throwing punches from behind. And so it kind of just takes the mother's testimony and really contradicts it and throws it out the window. And that's sort of when I started having doubt about the plaintiff's side of things, is that the neutral third party kind of confirmed the defense's side. And he has no reason to be biased towards either side. He apparently has been friendly with both the defendant as well as the mother and the son. No issues with either of them, and he's just there to give his account of what he saw. As for why the fight started in the first place, it seemed like both parties involved had a history of bad blood. The defendant claimed that the mom and son regularly called him derogatory slurs for the couple of years that the mom and son had lived in the building. On the other hand, the son claims that the defendant had regularly harassed him. But at the end of the day, I was waiting for it, and there was no smoking gun from the plaintiff's side that proved conclusively that the defendant had initiated the fight. And I should say, in a civil trial, the burden of proof is actually to an even lower standard than beyond a reasonable doubt as it would be in a criminal trial. All the plaintiff has to do is prove it's more likely than not that the defendant initiated the fight. But after looking at all the evidence, it was very hard to see that actually being the case, especially because the defense's arguments seem to be much more in sync with each other than the plaintiff's side. So the one thing that kind of bothered me out of this is that the plaintiff had to know that he had very little evidence to support his argument. So why did he take it so far as to sit in a courtroom for a week? His time must be valuable, so he must have had good reason for his actions and wanting to take it to trial, right? And so there were times here and there during the trial when the landlord was on the witness stand and when the property manager was on the witness stand, where they ended up alluding to other events and interactions that could have happened with the defendant. But every time it started to go in that direction, the defense would object and the judge would sustain, meaning that if the witness started talking, you would have to disregard that testimony and the witness could talk no further on the matter. So if there was something else that happened that would support a characterization as the defense as someone who might initiate a fight, we weren't allowed to hear about it or consider it when we as the jury were deliberating and making our decisions on the matter. And so with that, though, I do wonder if the landlord had a prior interaction with the defendant that made him uneasy, Why not at least install cameras at the property? Oh, cameras would have just saved such headache in this situation, I feel like. I hope at least the landlord now will go and install cameras in any buildings he owns that don't have them, because cameras are pretty useful in general. If you had a camera in that mailroom when the fight started, it would be over and done, clear exactly what happened, and it never would have had to go to trial. But anyway, we heard all the evidence as the jury, and once both sides rested their case, it was time for us to move into the jury deliberation room, at which point we just went around and asked, hey, is there anyone who is very strongly in favor of ruling for the defense? Had someone speak out. Anybody else kind of add to what they thought about that argument? And then on the other hand, we said, is there anyone who's feeling very strongly in favor of the plaintiff, which would mean that they felt more likely than not that the defendant was the one to initiate the fight, and there was only one person who thought that they should rule in favor of the plaintiff. We needed 9 people out of the 12 to rule in favor of a particular party to issue a verdict. And so from the get-go, it was 11 of us in favor of the defendant, 1 person in favor of the plaintiff, and his reasoning seemed to stem from his own experiences with a property manager that he had become acquainted with, the building he lived in, which was outside of the evidence presented us in the courtroom and outside of the judge's instructions to the jury on what you're able to consider when ruling and deciding a verdict. So it was pretty clear that we were all in favor of the defendant, and so we ruled in favor of the defendant against eviction, and that was that. So that was my first experience on a jury, in a courtroom, sitting in on a trial. Like I said, it was an interesting experience, one that I hope to not have to do again anytime soon, but it did teach me a lot about the justice system. And there's certainly much more to the case than I was able to state here. I didn't want this video to drag on for ages. There were other highlights, like there was this gotcha moment where the property manager had claimed he didn't have much contact, or the defendant didn't reach out to him to try to explain his side of the story. And then the defense attorney drops a packet of papers of phone records and is like, is this your phone number? Yeah, so the defendant tried to call you 6 times between 6 and 6:30, and then he called you the next day. Also, here are text messages of the defendant asking you to call and talk to him. I was like, oh, dang, this is some TV stuff. And then you had, just out of nowhere, at the end of cross-examination on the defendant, the plaintiff's attorney just yells out, do you beat your wife? And then it's like, whoa, where did that go? What the heck? It was out of nowhere. And it's like, do you expect him to just say it before the defense has time to object and the judge has time to be like, yo, what the hell are you on about here? That was wild. All in all, it was just the defense attorney, I felt like he was on a different level than the plaintiff's attorney. And he just presented a much more well thought out case. And I thought he did do a better job overall. So that's how the thing went. Anyway, if you've stayed this far in the video, I appreciate it. I'm glad you were interested in hearing about it. Thought I'd make a video on it. Thanks for watching, and hopefully I won't have too many cases to tell you about in the future. I'm happy to be sitting in front of my computer all day again. So thanks for tuning in, though. If you liked, check out the playlist if you want other vlogs, I guess, but there's not going to be other court case recaps, I suppose. Subscribe to the channel if you're not already for mostly gaming stuff, not court case recaps, and I'll see you next time around.